Welcome back to the Law and Crime Network, folks. I'm Aaron Keller. I'll be with you through the afternoon hours here as we continue to listen to testimony in the Daniel Tate case out of Kenosha, Wisconsin. This is the case of a 20-year-old defendant in a so-called murder on the beach case. The accusation here is that this defendant killed a 17-year-old named Olivia McKay by luring her there with the discussion of some kind of kinky sex, and that once she was there, he choked her and then put her head underwater and basically drowned her while he was choking her to death. A friend of the defendant's was there for a lot of it. He testified in this case. There were a lot of attacks as to whether or not his testimony was credible. We also heard some interesting testimony in this case earlier today about previous girlfriends of the defendants who said, yeah, he was involved in all of this kinky sex, this choking and whatnot. It's really interesting that that wound up in this trial. I know some of our other hosts here were concerned about how many of those so-called prior bad acts would actually really help the state here, because maybe those prior acts would help the defendant and he could say, oh, yeah, that's what I was really doing. And it just resulted in her death. In other words, the death wasn't intentional. Therefore, the state can't prove first-degree intentional homicide. It's going to be really interesting to see how the state tries to link this all together. We have two guests to help us break down this testimony while we're in a break. Francey Hakes is with us from the Los Angeles area, and David Katz is with us from Beverly Hills. Welcome to you both on the far West Coast.
Thanks, Aaron.
Good afternoon.
Good to see you both. So what do you make of this? I mean, this is really an interesting case. The accusations are horrific, as they always are in cases of this nature. You've got a 17-year-old victim who shows up, and then the accusation from the cooperating defendant is that this defendant, Daniel Tate, just put her in a sleeper hold until she basically passed out and then choked her while holding her head was underwater. I'm trying to figure out where in that these other bad acts of, you know, choking during sex, which was apparently somehow consensual, how does that allegation play into the accusation that this is how this murder went down? Francey, do you want to take a crack at that first?
Sure. Thanks, Aaron. It's always really interesting, prior bad acts, especially in a case like this, where the defense is probably going to argue in closing arguments, sure, he strangled these other women during sex as part of the erotica part of the sex, but he didn't kill them. So there's no reason to think he intentionally killed poor Olivia McKay here. The problem for him, I think, is that you now have these text messages, and his trying to sell her car certainly indicates that the car may have very well have been a motive for murder, and it also shows a terrible callousness. It's not like anybody called 911. It's not like anybody tried to rescue her. They treated her like a piece of garbage. He dragged her by the hair. So I think all of these things work against the defense when you combine them with the evidence from the other witnesses of his prior history.
I'll agree with you on that, Francey, and let me sort of frame it up this way. Initially, when we were in this trial earlier this week, I'm like, okay, whenever you get these cooperating defendants, it's one defendant's word against another one's, but I think these text messages are really pointing the finger further towards Tate as being the killer here than the cooperating defendant. Okay, the text messages of the disposal of the vehicle are really making Tate look more like the guilty party. I agree with that, but let me switch over, David, and ask you about this one. I was sitting here trying to figure out how this consensual choking during sex plays a role in this. Do you think the prosecution is going to turn around and argue, okay, even if he was engaged in this stuff in the past, this was not that because it resulted in a death, and that's why we know, you know, he had experience knowing how much pressure to apply and when to let up on the pressure. That's what makes this intentional murder, because it didn't come out like the other episodes. Is that where they're potentially going with this?
Well, I think they may have overplayed their hand with this because, like you said, if nothing happened before with any of these other women that he was with and he engaged in pretty much the same conduct, then why should we think that this one, you know, went so awry? And so I think that's always the problem with prior similar acts. It has to be very, very tightly wound in, so you really see a pattern of not only the conduct but the kind of harm that occurred in this situation. Otherwise, I don't think that it really hurts them that much. And I take your point about how do you know it was Tate and it was not Cook? But I just imagine that Cook's defense attorney That may be his theory, but Tate's defense attorney, the fellow who's on trial right here, he's going to say Cook did it. Cook's fingerprint was on the bag. It's easy for Cook to say that Tate did it. He's cooperating. Of course, that's what he's going to say. He's going to want a break.
Yeah, this is always a back and forth when this happens, but I agree with Francey's point earlier, and some of those text messages we just heard about the disposal of the vehicle. You know, why is Tate the one that's so quick to try to get rid of the vehicle? You know, I mean, how's he going to explain that away? Or is this a case where Tate's going to get up on the stand and directly point the finger at the co-defendant? Wouldn't that be interesting? Francey, what do you think?
Yeah, you know, Aaron, defendants do testify, but they almost never testify in a case like this. There's a lot of risk in his testifying. The cross-examination by the state could be brutal for him, especially when he's going to be asked about his penchant for enjoying hurting women. I just don't think that his defense attorney will let him take that chance. I think they will stand on pointing the finger at the co-defendant who, let's be honest, when he testified earlier, he does not come across as a very sympathetic character. His affect was completely flat during his testimony. He looked like he couldn't care less that he was witnessing a murder. It made him look extremely callous.
Oh, yeah, he just says, oh, I looked away because I didn't want to see somebody die. That was one version of it. Then he had another version of it. So which version of it is it? I mean, he admits to being there. The fingerprints suggest he was there, but I agree. Yeah, he came across poorly. What would it be like if Tate gets up on the stand himself? Okay, you know, because I understand, Francey, look, the attorney can say, hey, this is going to be a bad idea, but it's ultimately the defendant's choice, not the attorney's. And we see the judge ask defendants in every case, do you want to testify? Did you get properly counseled on this? Are you comfortable making a decision, et cetera, et cetera, et cetera? But what if Tate gets up on the stand and tells a completely different version of this thing and says, oh, yeah, I was really helping my buddy Cook dispose of this because he asked me to, and then you've got a totally different version of the events. How's the jury reconcile it? David, what do you think?
Well, as a criminal defense attorney, you know, I've been trying cases since I left the U.S. Attorney's Office for about 25, 26 years. I've had acquittals. I've often surprised the prosecutor by calling the defendant to the stand. And a lot of people think it's unorthodox, but I've found it successful in the terms of acquittals and hung juries. And the defendant has a huge advantage in a criminal case. A lot of disadvantages, but you get the last word. You get to testify last. They may call a reply case, a rebuttal case, but the reality is your client pretty much has the last word. And if you have a coherent theory of what happened, which is that the other guy did it, you get to hear what he has to say first. You get to look at all of the evidence. And so it's not a foolhardy thing. And as I said, I've tried cases all over the country and had people acquitted. The main problem is if your client has a bad criminal defense record that can be used against him or her, that's always a problem. But there are ways to even mitigate that, because the fact that a person's committed a crime in the past doesn't mean they committed this one. And the fact that their credibility may be questioned, it doesn't mean that other witnesses can't be questioned. And you look at this guy Cook, who's testifying. He was impeached up one side and down the other, including.
Oh, yeah. You know, and it's like I'm curious to see how his proceeding is going to go along, because it's scheduled for, I think, next week, to try to figure out how to deal with his case after he's now testified in Tate's case. Look, we're going to keep trying to break this down for you folks watching the trial of the so-called murder on the beach. Victim Olivia McKay, 17 years old, was strangled to death while her head was being held underwater. Those are the accusations. The charges are that Daniel Tate was the primary aggressor here and that one of his friends helped him dispose of that young girl's body and then made off with the car along with this defendant. So we're going to take a quick break. We'll be back with more analysis here on Law and Crime in just a moment. Welcome back, folks. That was some of the defense's opening statement in the so-called murder on the beach case. And again, here we hear the defense saying, hey, look, Jamari Cook, the cooperating defendant, has made up multiple different versions of this story. And members of the jury, you really can't trust either one, including the version where Cook says Tate, the defendant, is the one who committed most of the vile acts here. Francey Hakes and David Katz remain on the line with us here at the Law and Crime Network from the West Coast. So this seems, folks, like a pretty common tactic in cases like this. If you're the defense, point the finger at the cooperating witnesses, right, Francey?
That's right. That's what happens in every case where there are two or more defendants. And the state has the challenge of bolstering the credibility of Cook. And I think they've done a pretty good job so far. They have other witnesses talking about Tate's penchant for strangling women during sex. They've got Tate's behavior after the crime when he was trying to get rid of the car and clearly taking the lead on trying to sell that car. But most importantly, Aaron, it was Tate who lured Olivia McKay online to that location, not Cook.
Yeah, most of the key communications here are coming out of Tate as it relates to this victim. Getting her there, I agree, and then dealing with her car after the fact. The car evidence came in this afternoon. Now, David, I think the prosecutors in this case are very skilled. Julie Rendelman was here yesterday with me, and she said these guys are good. And I agree. I think that they're asking some great pointed questions. And I think that these text messages about the vehicle are really leading me to believe, hey, Tate is the primary guy here. What do you think?
Well, the prosecution has to prove the case beyond a reasonable doubt. And so that's always the problem if you don't have a lot of physical evidence. What I've heard of the physical evidence so far is that there's a fingerprint, but it's not Tate's. It's Cook's. And it's on the bag which contained the corpse, the body of this poor girl. And so that's not good. And the fact that the car was sold afterwards, they tried to sell the car afterwards, once the thing has happened, they tried to sell the car, which is, shameful and awful, but it doesn't make you a murderer.
Yeah, look, physical evidence is great, but here we've got all these text messages, and if they're not physical evidence, they're a window directly into the defendant's mind, and he was really scurrying to try to get rid of that vehicle. Is that evidence of a guilty conscience? That's the question that the jurors are going to have to ultimately answer. It looks like we're getting ready to go back into court. So, Francey, maybe I'll throw that question at you. Is that evidence of a guilty conscience? He's the one that's going, ASAP, ASAP, ASAP. We heard that in one of those messages. He wants that car out of his possession.
He does, Aaron, and all due respect to David, he's got such a great defense attorney perspective where he takes each individual piece of evidence and sows some doubt about it. But that's not how criminal cases work, and that's not how crimes work. It's what's the totality of the evidence. And you also have text messages between Tate and his girlfriend right after the murder where he's telling her he desperately needs to talk to her. Is she still going to love him after he tells her what he needs to tell her? That certainly suggests consciousness of guilt as much as many of these other texts do.
Yeah, I agree. Totality of the evidence, because jurors want a story here, and jurors could, in theory, David, still wind up with a conviction here if they say, hey, look, so what if this one evidence, this one witness, Jamari Cook, is up on the stand? So what if he's fudging a little bit? He's facing his own charges in this case. The bottom line is we don't have Jamari Cook's text messages up on the screen. We've got Daniel Tate's. And unless the defendant is going to really, ram in there that there could be more evidence out there or something like that, this looks like a strong case against the defendant, but we're going to go back to court because it looks like things are picking back up. So let's hold that thought. Let's go back live to the so-called murder on the beach case. Okay, folks. Yeah, this is an interesting little evidence back and forth that's happening in court right now as to whether or not this witness is going to be allowed to testify about an interrogation that this witness wasn't a party to, but that this witness later reviewed. Look, our guests are here, Francey Hakes and David Katz. They sent the jury out to try to argue this around, Francey, I heard you say it, and I agree with you that the defense has got the law correct on this. A witness is supposed to be able to testify to what the witness has seen or heard, him or herself, unless the witness is some kind of an expert witness. And I don't remember any discussion that this guy was qualified as an expert, to testify about what someone else could have testified to.
No, and that's the thing, Aaron. The prosecutor cited that he was impeached and this was a prior consistent statement, but it's not his statement. It's the statement of Jamari Cook. So unfortunately, against my inclinations, I have to go with the defense attorney on this deal point.
Yeah, I think this is just a basic question about, what can a witness testify about? And, if I didn't see it or hear it or observe it, or, you know, whatever, hear it with my own senses, I can't really testify about it. But I want to listen to some of these evidence arguments that are happening right now. Instead of an evidence argument in the courtroom in Wisconsin where the murder case of Daniel Tate is being heard. He's 20 years old and he's accused of killing 17-year-old Olivia McKay on the shore of Lake Michigan in a so-called murder on the beach case. Now, Francey Hakes and David Katz are with us here on the Law and Crime Network. We're hearing this big discussion about hearsay rules and whether or not the defense is, or rather whether the state is going to be allowed to question this police detective about an interrogation that other detectives did and that this detective wasn't part and parcel to. And the issues seem to be getting really muddy here. Francey, what do you take of this? Hearsay, is there an exception that would allow this witness to testify about an interrogation that he was not present for?
It's interesting, Aaron. This started off as an argument about hearsay, and then it went into confrontation clause issues, and then the business records exception. In federal court, most police records are not considered business records, and that would not be an exception to the hearsay rule. I don't quite understand the argument here. I think the state is in the wrong, although the judge's final ruling, I think, will be okay on appeal. But I think the state, if they wanted to get in what they're talking about, they should have recalled Jamari Cook or the detective who took that statement from him.
It would seem to me that that would be the proper way to rehabilitate this. David, what do you think?
Well, I agree with Francey and you on this, that this would be the proper way to rehabilitate it, either through Cook or through the officer who actually heard the statement being made. This could not be allowed in federal court, at least the way it's been presented so far. And I can't imagine there's really an exception in Wisconsin law that would cover this. I'd also point out that they spent a lot more time on this than it would have taken to just call the police officer who actually heard the statement right after this officer and have him say, I heard such a statement on this other day. But if you were to allow this, you would just have one investigating officer. The investigating officer would say, I've read all, excuse me. The investigating officer would say, I've read all the documents in the file and I'm ready to testify about everything that's in all the police reports. One witness, case over, defendant convicted on a whole bunch of hearsay and double hearsay. So this is very strange, and I'm a little surprised that it's gone on this long and that the judge hasn't just curtailed it. We know in federal court that the judges don't like these sidebars. They don't like to send jurors out. And this is one of the reasons why. It gets very distracting for jurors. They've been out of the courtroom all this time. And like I said, this could have all been taken care of with the police officer who actually took the statement. I assume it's a recorded statement, either video or audio.
Yeah. David, we've got action back in court. Apparently this is picked back up again in some fashion. I'm not sure if the jury's back in the room, but let's listen into where this is going. Interesting witness there in the so-called murder on the beach case out of Kenosha, Wisconsin, the case of 20-year-old Daniel Tate, who's accused of killing 17-year-old Olivia McKay on the shore of Lake Michigan by strangling her and holding her head underwater while strangling her. That was just a direct examination and a cross of a former girlfriend of defendant Daniel Tate. And we heard a lot of back and forth there about Jamari Cook. Now, Cook is the co-defendant in this case. He's not charged with murder. He's charged with the other two charges that Tate is facing. Those charges are hiding a corpse and taking or driving a vehicle without consent. What the defense was trying to hammer at there is, hey, look, you know, they both were at this night's inn, and Cook was the one who was throwing items into a dumpster from the vehicle, presumably here. Does that mean Cook was more involved than the state wants to lead the jurors to believe? And the insinuation that the defense wants is, yes, the defense is saying Cook was the real killer and that they're trying to throw Daniel Tate under the bus. So just really quickly here as we wrap up for the day, Francey Hakes is on the line with us. David Katz is on the line. We are expecting this trial to wrap up relatively shortly. Those might have been the final prosecution witnesses. Francey, does the state have the case beyond a reasonable doubt? What do you think?
I think they do. I think they have introduced plenty of evidence showing that Daniel Tate was the person who lured the victim out to the beach, was the person who strangled the victim until she was dead, was the person who was pushing the sail of the car, and was the person who hasn't told the truth to police and who has the history of strangling women. I think I did hear the prosecutor say that after they were checking to make sure all their evidence had been admitted as they thought, that they were going to rest. So I'll be very interested to see if the defense puts on a case, but I think the state made theirs.
Yeah, Francey, just to let folks know what happened just seconds ago in court, the state rested its case. The defense rested. No defendant testimony, no defense case whatsoever. David Katz, you do defense work in Beverly Hills. No defense case here. Look, the defense doesn't have to prove anything. The defense just has to point to reasonable doubt. But apparently no defense case here. What do you think? What do you make of it?
Well, I think they raised some doubt, certainly through the inconsistent and self-serving statements of this fellow Cook. And Cook got what they'll characterize as a sweetheart deal. I mean, driving around a corpse is not much of a charge, or driving around a car without permission after you've been charged with first-degree murder along with Tate. But I do tend to agree with Francey on the main point that there certainly is enough there for the jury to convict beyond a reasonable doubt. And this case would not be reversed on appeal because of insufficient evidence. Having said that, it can be a high burden in a particular case. They need all 12 jurors to convict. This last piece of evidence, Francey was talking before about the totality of the evidence. I certainly get it. And while there are a lot of pieces that don't fit together very well in this case, this last witness was really devastating to the defense, because if you're running around trying to sell a car under those circumstances, sure, that could have been an idea that you hatched after the co-defendant killed somebody, but it's a little hard in human nature to accept, right? That grieving and thinking, God, I'm in this way over my head. You're trying to sell the car just soon afterwards. That's a bad piece of evidence for the defense.
Yeah, look, I mean, I think that the takeaway there is that the witness's instincts were correct. She's asking, hey, why don't you have title? Whose name are the plates under? And it's all this, never mind the man behind the curtain responses that she was getting back from Tate, her ex-boyfriend. The witness's instincts were correct. I thought that testimony was quick, it was pointed, and it was on the money. This makes it look like Tate is basically paranoid about unloading this 17-year-old victim's vehicle. Why was it not Cook who was unloading it? I'm back to apparently hearing nothing from the defendant himself, and I know that he doesn't have to say anything. But if it was really somebody else, why doesn't the defendant get up there and say it's somebody else? And I know that I shouldn't go there. I know I shouldn't ask that question, but one has to wonder if that's what the jurors are going to ask.
Well, I don't know.
Yeah, Aaron, that is what. Oh, sorry, David. Go ahead.
I was just going to say, I don't know all the backstory, but sometimes a defendant has a criminal record, which makes it it's dangerous to even take the stand. And he'd probably get questions, too, about these other choking incidents. And on top of that, he really has raised some reasonable doubt through the testimony about the other defendant, about Cook.
Yeah, I do have one more question that I was going to throw on the table here, because apparently closings are going to begin tomorrow at 9 o'clock. I'm assuming that's 9 o'clock Central Time, which would be 10 o'clock here on the East Coast, even later for those of you, including you, David, and you, Francey, who are on the West Coast. But, we heard a lot of questions from the defense today about how the interrogation of the cooperating witness, Jamari Cook, was handled, and it sounded almost virtually identical to the sort of questioning that we were talking about earlier this case that the U.S. Supreme Court did not pick up in the Making a Murderer case. That's the Brendan Dassey case. Could it possibly be that Jamari Cook, the cooperating witness, was sort of slowly coerced into a version of this story because he wanted to cooperate or please the interrogator? And again, I don't think that questioning was really helpful for the jury, but were those attorneys really speaking to an appeals court? Francey, what do you think?
I think you're absolutely right, Aaron. I think they're always talking to the appeals court when they roll the dice on a trial that's got good evidence like this one does. But they're also talking to the jury. They're trying to suggest they specifically asked the detective several times, basically whether he was putting words in Cook's mouth. There's no doubt that in closing arguments tomorrow, the defense will point a big fat finger at Jamari Cook and make it seem like he is the one who did the killing. They were talking about how much bigger he was than Tate, I suspect they're going to then just extrapolate for the jury that Tate might have been intimidated by Cook, even though I don't believe we heard any evidence of that. It won't stop them from making that inference. So it should be interesting closing arguments, but I think the defense has an uphill battle here.
I agree. David, final thoughts from you, speaking to the appeals court versus speaking to the jury.
Well, it's always good to have a plan B when you try a case and have a theory of, trying to get in evidence. I mean, part of it is to win, but part of
Well, I think we lost you there, David. Sorry about that. So we're going to wrap up the broadcast today here. This was really the last question I wanted to jump into. David, you may have snapped back there for a second, but the feed froze up. Sorry about that. We didn't hear much of your response. Sometimes the internet gets clogged. So we're going to wrap up the broadcast today, though, because closing statements in the Murder on the Beach case will be tomorrow morning here on the Law and Crime Network. And a reminder to everyone who's watching, we also are continuing to follow the Richardson and Hayes case out of Florida. That's the case where a 22-month-old named Aiden McClendon was shot and killed in the crossfire in what prosecutors are alleging was a gang attack on that 22-month-old victim's cousin. So we are still covering that case. Of course, if you want to see the raw feeds as they come into us here at Law and Crime, you can always go to lawandcrime.com, or you can use our mobile app. So we're going to wrap up right now. Francey Hakes, David Katz, appreciate you joining us here on Law and Crime today. This is Aaron Keller, and for everybody here at Law and Crime, have a good evening. We'll see you tomorrow.